Washington Journal continues.
During his list of accomplishments, our guest David Rivkin served at the Justice Department from 1981 to 89 as Deputy Director for the Policy Development, serves as a constitutional law attorney. Here to talk about the citizenship question. Good morning.
Good to be with you.
You talk about a certain approach that the administration could take in getting the question on the 2020 census. What's that approach?
The administration could argue that Section 2 of the 14th Amendment compels federal government to obtain information about the breakdown by state of the citizen numbers. It could be done by executive order that the president would sign ordering the Department of Commerce to put this question on the census. I also want to emphasize, a lot of people misunderstand this, that the Supreme Court decision that was issued nearly 2 weeks ago specifically stated, 5-4 majority, that it's permissible to ask this question under the Census Act, which means Congress did not use its vote to block the president from doing that. The problem was entirely procedural, not to minimize the significance of procedural infirmities, but it is certainly something that can be cured. And it happens all the time where a government agency or department does something it has power under the organic statute to accomplish, just doesn't do it well. Happens to EPA all the time, happens to a bunch of other agencies and departments.
So when it comes to that Section 2 of the 14th Amendment, just to read from the op-ed you wrote on this, and you can find it at our website and online, you said the Section 2 of the 14th Amendment provides that if a state denies the franchise to anyone eligible to vote, its allotment of House seats shall be reduced to the proportion to the number of such citizens bear the whole number of citizens in each state. The language is absolute and mandatory. Compliance is impossible without counting to many citizens live in each state. Can you expand on that and talk about where that comes from?
Yeah, it comes from, it's part of a post-Civil War amendments. The idea was to provide, you have other amendments, including the 15th Amendment and Section 1 of the 14th Amendment, and in essence, prevent the states from engaging in discrimination and denying citizens' right to vote. By the way, Pedro, at the time, only male citizens 21 years and older were allowed to vote. Obviously, it was changed by the 19th and 26th Amendments. What this language tried to do is to come up with a mechanism of penalizing states that disfranchised a portion of their citizens. And it was not, the original version of that language involved references to race. That got changed to a more generic language. There's, of course, reference to race and color in the 15th Amendment. And I'm perfectly aware of the fact, it's been pointed out to many people who tweeted about it, that this language has never been used by Congress. But it doesn't matter. There are a lot of provisions in the Constitution that have not been utilized, and other provisions of post-Civil War amendments have been essentially moribund in an enforcement sense for many, many, many decades. But it is a provision that has to be enforced, and the only person who can do that is the president. Now, why census, which is another point I've heard mentioned. Section 2 of the 14th Amendment actually amends Section 2 of Article 1, which is the very same section that deals with the census. So that information is meant to be gained for the census. And again, the president is the only one who can do that. Congress obviously does not run the census. But what's important is Congress never objected statutorily to the discharge of its constitutional duty. The Census Act does not specifically mention this, but nothing in the Census Act prevents the president from doing it. How do we know that? Because the Supreme Court said 5-4 in the census case that citizenship question is permissible under the organic statute, that being the Census Act.
Our guest with us to talk about the citizenship question on the 2020 census and his arguments that he lays out in an op-ed. Again, you can find that online. If you want to ask him questions about it, you can call us 202-748-8000 for Democrats, 202-748-8001 for Republicans, and Independents 202-748-8002. If this is done by executive order, is that a weaker way of going about getting this done versus the other?
It's a stronger way, Pedro, in two ways. First of all, it can be done quickly. Second of all, the president proceeds in that fashion. You basically take off the table all of Administrative Procedures Act type questions about amassing the record. I mean, really, if the president did it by executive order, the sole question on the table would be, is this constitutional? Is this within the scope of the president's powers? And the answer very clearly is yes. The other interesting tidbit here is that the criticism that Supreme Court has not addressed, but been lodged by the opponents of this question below, is the Equal Protection Clause. The argument being that doing this somehow discriminates against certain portions of a population, therefore violates the Equal Protection Clause. Interestingly enough, the Supreme Court, and I mentioned this case, it's called Richardson, in 1974, entertained a challenge to the California policy of disfranchising ex-felons. Very controversial issue politically, but the argument was that that policy contravenes the Equal Protection Clause, which is a clause of Section 1 of the 14th Amendment. Supreme Court parsed both Section 1 and Section 2, and specifically made a very clear point that something that is expressly allowed under Section 2, and Section 2 allows abridgment of voting rights of citizens who participated in rebellion or of a crime. So the court said you cannot possibly violate Equal Protection Clause by doing something that's specifically contemplated in Section 2. You know, people who wrote the 14th Amendment were not at war with themselves. That pretty definitively answers the question of whether or not a Section 2 compliant policy, a Section 2 driven policy, can never be considered a violation of Equal Protection Clause of Section 1.
There's a gentleman at the Witherspoon Institute in Princeton, New Jersey, named Matthew Frank. He writes for National Review. Looked at your analysis of the approach you take of the op-ed, and he had this to say about it. I want to get your response. He said this: note that the amendment on the 14th Amendment does not actually protect anyone's voting rights by any direct enforcement action of the federal government. It simply imposes a cost on states that deny the suffrage, and again, only if they deny it to its male citizens 21 or more years of age. But it's the worst kind of, quote, keeping the Constitution in tune with the times nonsense to say that today's, quote, male citizens over 21 actually means, quote, all eligible voters, as Rivkin and Gray blithely claim.
I read the piece, to put it gently. He is wrong for a couple of reasons. First of all, obviously, the reference in Section 2 was to male citizens. The franchise was changed, and properly so, legitimately so, and in my opinion, perfectly good thing in the 19th and 26th Amendment. The fact that the reference there is to male citizens does not alter. That's how the Constitution works. You just layer things on top of it. The other point he makes, which is kind of, frankly, silly, is that he does not see much of an opportunity for judicial enforcement. That's not necessarily true, but there are numerous provisions in the Constitution, Pedro, that are not judicially enforceable. Among other things, they can be something that's judiciary is not equipped to enforce. It's called political question doctrine. Doesn't mean they're not binding. And the notion that the clear constitutional command, I can tell you this much as a practicing lawyer and a constitutional, maybe, and I hope, I don't know of any Supreme Court case that ever held that any constitutional language somehow became moribund because it has not been sufficiently enforced. The only way you can supplant a constitutional language is having a constitutional amendment that specifically vitiates it, which happened in the original language, the infamous 3/5 clause in Article 1 was changed by Section 1 of the 14th Amendment. So he's just wrong. And what's interesting, the reason I emphasize the 1974 case, the Supreme Court in a 6-3 decision in 1974, which was after the 19th Amendment and 26th Amendment were ratified, instead of treating Section 2 as moribund, treated it that as a pivotal part of its decision that the California policy of not allowing ex-felons to vote was constitutional. Interestingly enough, the minority, the free justices on the Supreme Court in 74, made essentially the same point as Mr. Frank about what, in their opinion, was wrong with Section 2 of the 14th Amendment because it only protected a portion of, by that point in time, eligible electorate. 6 justices disagree, so I'm happy to be the Supreme Court majority on this.
Before we let you go to calls, there's stories this morning that the Attorney General himself saying now he sees a path forward in getting this question on the census. Do you suspect that the path he sees may be the one that you advocate for?
I'm hoping that that is the case. I think it is a good path. It's not the only path, but it's the most expeditious path. And I have a lot of regard and respect for DOJ. I think they will find the right way to proceed.
Did you ask him? Did you talk to DOJ specifically about this path at all?
No. They can figure out what they want to do themselves.
Let's go to calls. Our first one is from Rhode Island this morning. Republican line, Jack, you're on with David Rivkin. Go ahead.
Thank you very much. I'm not a lawyer. I'm a retired engineer, but my ancestors came into the United States from Germany in the 1880s. Now, I don't know what the immigration laws were then at that time. So my grandparents now, obviously my grandparents were born here, but my ancestors came. They had skills, like they were tool makers, and I'm a retired manufacturing engineer now. So I just like to know, what were the immigration laws at that time in the United States? And I overall support the question as to citizenship. It should be asked.
Okay, thanks, caller.
The immigration laws throughout much of American history were quite unrestricted. We were essentially welcomed, pretty much everybody, with very few exceptions, and until the advent of infamous Chinese Exclusion Acts, sort of a first effort to cabin certain types of immigrants, the Chinese, from arriving here. That was the political judgment that was made properly, and it was not sort of done in a resistance mode. It was political judgment made by Congress at the time, and it made perfect sense. But to be clear, there's actually a good relationship, in my opinion, quite aside from Section 2, having a good snapshot of the distribution of citizens and non-citizens throughout the country, and seeing from one census to another what the trends are, helps, in my opinion, it's a secondary point, but still helps have a more informed discourse, hopefully civilized debate about immigration.
Seattle, Washington. Eric is next. He's calling on our line for independence. Good morning, you're on.
Good morning. Thank you. I feel like something that would help the census is two things. Number one, we need to stop changing people's nationality when they come here to the United States. For instance, what I'm saying is that they are considered Russian, German, Chinese, or whatever, where they come from. But when they come to the United States, Russians are allowed to just say they're white people. So once people get to the United States, all Caucasian people from wherever you're from Poland, you're just considered white.
So caller, how does this specifically relate to the citizenship question, and what would you like to ask our guest about it?
I would like please let me finish, Pedro. I would like to ask him this. Trump's family, for instance, his mother was an immigrant. She came here. His two wives, are they accounted on the census? Both of them are immigrants.
Okay, caller, thanks.
I think this country benefits from immigration. Look, I was not born in the United States myself. I came here as a refugee, as a young lad. To me, asking the question about citizenship does not discriminate against anybody and does not block anybody from coming here. Now, I happen to believe that people should come here legally. I happen to think that illegal immigration is something that needs to be properly managed, but I don't see a problem with asking the citizenship question. And by the way, it's useful for your listeners, viewers, to appreciate the fact this question has been asked until 1950 in every single census. And it continues to be asked, even after 1950, on a sample of the census forms. So the notion that this is somehow extraordinary is my opinion, quite frankly, untrue.
So the concerns then of the undercount or the viability, if you take in that kind of question, what it would do for the count overall?
Yeah, I am not a statistician, but I find it very implausible. There are very strong laws in place that bar the misuse of information obtained. It says, one of a quick point in that, there are two criticisms I heard about what would be consequences of putting the citizenship question in the census. One is it would precipitate considerable percentage of people to fail to respond. The second is it would not be accurate because they'll lie in a sense of somebody's not a citizen saying, I am a citizen. I don't see logically, Pedro, how both of those things can be true.
Let's hear it from North Carolina. Mike is next, Republican line. Go ahead, please.
Good morning. Is it true that the citizenship question was on the census and that the Obama administration had it removed? Thank you.
To be honest, I do not have any idea if that is true. It's conceivable that question, the preparation of citizenship forms, from what I understand, takes a long time. But look, one of the things I'd like to suggest benefits not only the debate about this issue, but other issues. who cares what happened a long time ago and who did what to whom? The real question, as far as the interagency battles are concerned over this process, the real question is, does it make sense to ask this question? Is that constitutionally permissible and even required, as I believe? Is it legally permissible? Because remember, the critics, for example, it's not the question this caller raised. The critics are pointing out there's some gentleman who died in 2015 who wrote some memos suggesting that adding this question might be politically beneficial to Republicans. I mean, who cares if that, to the extent it had any impact on this process? That's, I mean, to me, it just doesn't do much for the quality of our discourse to be pointing fingers and playing gotcha game.
You were previously at the Justice Department. There was reporting saying that the legal team initially tasked to this questions being replaced, and then those lawyers may be coming from the Civil Division and the Consumer Protection Branch. Is there anything to that you might add as far as their ability to take this question differently than the previous team?
No, from what I understand, the people who originally defended the census rulemaking were part of a federal programs branch, and they are bringing part of a civil division. They're bringing other people, civil division, including the Deputy Assistant Attorney General. Happens all the time. I remember when I was litigating a number of years ago, a challenge to Obamacare, individual insurance purchase mandate, very quickly, in my case, that's the case that eventually went to the Supreme Court. We had somebody who was at that point in time a Deputy Assistant Attorney General for Civil Division replace the number of line attorneys. That happens all the time as litigation unfolds. I wouldn't draw any implications and speculate that the career, first of all, we're talking about career lawyers still being involved from a different section of the Civil Division, that career lawyers are not, original set of career lawyers are not prepared to defend this case. They're just plain silly.
Virginia is next. Virginia is from Riverside, California, Democrats line. Hi.
Hi. Glad to speak this morning. I had a question or two for this gentleman. Under his breath, when he originally started talking about this, he was saying, in my opinion, in my opinion, in my opinion. Where is it documented in his opinion, and where is it in black and white in 1952? I'm 75 years old, and I understand the census, and I've never been asked that question, and I've been here a while. Also, the question on Melania's parents. Didn't they just drop in a few years ago or last year? Where are they going to be questioned? Are they citizens because Trump's president, or what's going on with that affair? It's kind of interesting. Good question, I think.
All right.
Well, on the first question, change came in 1950. Again, if you look at the duration, most of our history, the question was asked. Even under 1950, the caller needs to appreciate the fact it's not being asked now on all the census forms, so-called short forms, been asked in the long forms, which, if I'm not mistaken, is like 4 to 6%. As to a question about Trump's parents, or not Trump's parents, I imagine the parents of Melania. I have no idea, but I'm sure they're going to get the form. But with respect, I don't see what it matters. Again, the real issue is, why does it make sense to ask this question? Is that legal?
If it goes the executive order route, talk about the legal challenges. What does it face?
There will be legal challenges. I suspect, unfortunately, even though I think it's eminently defensible, the lower courts, the same two district courts that have stopped the rulemaking from being implemented, would rule against the administration. As I suggested in my piece, the administration is going to seek an emergency review by the Supreme Court during the summer. Quite unusual, but happened before in our history, and I have every confidence that the Supreme Court would uphold this.
The piece, by the way, how to put the citizenship back in the census. That's you can find on the Wall Street Journal's website if you want to read the thoughts of our guest. Wanda in California as well, in Chico, California, Republican line. You're next up. Good morning.
Yes. If you count all these illegals here in California, that's going to give California and other sanctuary states more representatives in Congress than is proper. So if they don't ask that question on the census form, I'll just boycott the whole census form altogether. That's how I can lower the count here in California. The census is going to be very inaccurate.
Okay.
Well, I would encourage everybody to respond to the census question. I understand, by the way, the concern that some people have expressed about the fact that you have states that sort of disproportionately attract illegal immigrants, undocumented immigrants, and therefore artificially beef up their allotment of seats in the House and their representation in the Electoral College. Your viewers need to understand that currently the apportionment is done, enumeration is being done based upon total population numbers. There are people who argue from time to time that you need to get back to the citizenship baseline. Important to underscore, this is not what this debate is about. We're talking about having a question that would give accurate information. We're not talking about changing the way in which the process unfolds.
Back to the Supreme Court for a bit. Were you surprised that maybe that the Chief Justice was the writer of the majority opinion on that decision?
I was surprised. I have a lot of regard for the Chief Justice. I happen to disagree with him strongly about this issue. And now, to be fair, the administration did not do a very good job at developing the record, well, not administration, the Commerce Department in particular. So they made themselves vulnerable. And the Chief Justice was undoubtedly concerned about the sloppy rulemaking record. On the other hand, Pedro, I got news. Most rulemakings are sloppy, in my opinion. The way things work in administrative law, that was good enough. And it's interesting, again, remember the chief, you had two different majorities. You had 5-4 majority for the proposition that was legal under the Census Act, and 5-4 majority, different majority. Chief joined the 4 liberal justices that it was improperly done. It's the first time in history where something was held to be violative of Administrative Procedures Act, not because it was arbitrary, capricious in any inherent sense, but because it was somehow pretextual. That the Compliance of Voting Rights Act, which was justification articulated by the Secretary of Commerce, was not the real reason. And I think there's a very compelling language in dissent that suggests clearly that a lot of times you develop something in the government where you have multiple reasons why you get there, and the reasons you choose to articulate may not be the most important reasons. So that's how things work. So I thought it was a wrong decision, but I think and it's another point that's very important to emphasize. Lots of critics are now saying, if the Trump administration comes out with another approach that violates the Supreme Court decision, with respect, they don't know what they're talking about or just being totally disingenuous. The court is very clear. You can take another stab at it and another stab at it. And again, happens all the time. Government agencies and departments are being forced to redo things by the courts all the time. It doesn't mean they cannot do a redo.
To the sloppiness then of the original argument, how would you boil that down?
I think this, for reasons that are probably obvious, became institutionally and politically very controversial. You had an instance where the number of career people in the Census Bureau were very much opposed to it, and they had to be dragged, in my opinion, kicking and screaming to implement the will of their political masters. By the way, that's called democracy. We're not talking about political masters from Mars. We're talking about political masters that reflect the policy preference of the administration that was voted in by whom? By the American people, by the majority of American people in the Electoral College, not to revisit that debate.
Let's go to Lake Worth, Florida, independent line. John, go ahead. Thanks for waiting.
Good morning, Pedro. If you could just give me a minute to make my point. Mr. Rivkin, I've seen you before. You're a brilliant light with Constitution issues, but you just kind of confused me with your answer to the woman from, I believe, Chico, California. How does this not affect apportionment and the Electoral College? I mean, isn't everything based on the census as far as representation goes? I mean, there are no 11 or 12 million illegals in this country. It's closer to 40 million illegals in this country. So I need a better answer from you regarding that, because to me it doesn't make sense. How do we base apportionment? How do we base the Electoral College if not for this census?
Well, thank you for the kind reference. The current law is using the total persons baseline. So think about it this way. the census numbers are going to come in. Assume the citizenship question is going to be on it. It would have two sets of numbers for each state. It would say this many citizens, this many non-citizens. Those numbers would be aggregated. So let's say the citizen number is 10 for this state and the non-citizen's number is 2. So it would be 12. That would be the total baseline that would go into it. The Supreme Court several years ago in a case called Evenwheel out of Texas dealt with a question there. The plaintiffs argued that it is constitutionally required to use the citizenship numbers. The Supreme Court was not impressed with that argument and rejected it, leaving on the table the question of whether or not states that wanted to use citizenship numbers instead of total persons could do so. So there's going to be quite a bit of litigation on this issue. But for purposes of 2020 census, all of your viewers need to be assured that having the citizenship question would not, repeat, not take off the table the non-citizens. The criticisms that you may have heard is that the non-citizens would be scared to answer. So they would take themselves out of the census, if you will. Back to my hypothetical, instead of having 10 and 2, you would have 10 and 1. But again, I'm not a statistician, but I don't think that question, that argument makes a whole lot of sense.
And this is from McLean, Virginia. Nadia, hello, Independent Line.
Hello. Sir, in my opinion, this administration, and in fact in the Supreme Court's opinion, this administration wanted to place the question, the citizenship question, on the census for extremely nefarious reasons. So in my opinion, this administration should be blocked from putting this question on the 2020 census. And coming forth with another reason is, quite frankly, unacceptable, because we know for a fact, and the Supreme Court stated they wanted the question for nefarious reasons. So why you are putting so much credibility in this administration baffles me. They're not about the democratic process. They're about suppressing votes. And let me tell you, there are factually, for a fact, other sources that are more accurate that we have to obtain citizenship numbers. That's a fact, sir.
Okay, a couple of things. Look, I'm a lawyer. I happen to be a Republican. I happen to be supporting this administration, not on all issues, but on many issues. But even if I felt totally differently, the law is the law, the Constitution is the Constitution. I'm not prepared, and it's a very unfortunate part of our debate, to sort of say, well, because it's a bad administration, because Trump is a bad guy, and the people who work for him are bad guys, nothing they do should be countenanced. I think it's wrong. It's un-American, frankly. The second point, look, I'm a lawyer. That's not what the Supreme Court said. The Supreme Court didn't say anything as far as the majority is concerned about nefarious motives. The Supreme Court said that the particular rationale put forward by the Secretary of Commerce, compliance with the Voting Rights Act, was not, let me use a colloquial term, was not the real reason. Didn't say it was a bad reason. It's a perfectly good reason. Didn't say it was the real reason. It happens all the time where EPA, Federal Energy Regulatory Commission, Securities and Exchange Commission have their rules struck down because of administrative deficiencies. Under the caller's logic with respect, the entire administrative state would come to a halt because you try something badly the first time, you cannot fix it. So it doesn't work like this. It doesn't work like this both as a fundamental philosophical matter about what you should do, and second, it doesn't work like this as a matter of law.
David Rivkin, constitutional lawyer and other law here in Washington, D.C., a longtime person of Washington as far as working in various administrations, served at the Justice Department as the former Deputy Director for Policy Development from 81 to 89. Here to talk about the citizenship question. Lee is next. Lee is from Georgia. Democrats line. Good morning.
Yeah, Mr. Rivkin, come on now, be honest with the people. You know that man who put in that book was hired by the Republican to do just what he did. Try to get that question put it on to the citizenship thing. And for the Republican advantage. It's plain as day now. Come on, be honest with the people. Don't sit on TV in front of your family, in front of the world, and tell a lie like y'all don't know what's going on. Y'all know that man was hired to do that. And another thing, that question had not been on there all these years. No, but I didn't take that question off the thing, off the citizenship thing. The question has been out of there for about 50 to 70 years. They stopped asking that question.
Okay, we'll let our guest respond.
Well, two things. Again, I don't know when this question was, what was the policy of the Obama administration. I frankly don't think it matters. But look, there's been all sorts of speculation about nefarious purposes of putting down this question. I, first of all, do not know what happened and what was in people's hearts and minds. Okay, I'm not prepared to speculate about it. What I'm prepared to say is that this question is constitutionally required, number one, and that would be true no matter what administration is in power. That question is legally defensible and permissible under the Census Act. And that's all that really matters to me. And I don't believe that this question would have any political implications as far as suppressing responses. Look, to the extent you want me to speculate, I would say, on the contrary, the people who are opposing it with such vigor are doing that because they do not want the true breakdown of citizens and non-citizens data to be available in this format, if you will, because they understand that that would have implications in the debate about immigration and many other matters. How having more information a bad thing in a democratic society? How is that? How is it better to make decisions about having the full facts?
One more call from Philadelphia, Republican line. Gil, your last call for this segment. Go ahead.
Hey, good morning. I just want to say this census question is a good question for immigrants who are legal in this country. It does not affect us because as a legal immigrant, when we enter in this country, they already have our record. Time we enter from our airports or our seaports, from work authorization to green card to a citizenship. So if this question differentiates between legals and illegals, so it's a good question, and I don't think any legal immigrant should have any problem with that. There is anything wrong with this question.
Okay.
Thank you.
I don't think there's anything wrong with this question. I think this is a good question. I also happen to think that even if you're an illegal immigrant, answering this question would not get you into any trouble, which is, again, I don't think people are going to under-respond to this. Again, I think this is fundamentally, look, there are two issues going on. One is a knee-jerk reaction that we sense from some callers, but also sense quite clearly in this day and age that anything this administration is doing is by definition wrong. Second is there are people who do not want to have the information about the total number of non-citizens in this country, legal and illegal. Now, this information does already exist. There are administrative records, Social Security Administration, IRS, et cetera, but having this information come for a census would endow it with additional credibility. And look, there are people who say we have 11 to 12 million illegal aliens, and there are people who say we have 20 or 30 million illegal aliens. I don't know what the right number is. But having, again, this information is a useful key fact to work into the debate. And the people who don't want it, again, are not, frankly, doing justice to their own position.
The Wall Street Journal piece is called How to Put Citizenship Back in the Census. David Rivkin, one of the co-authors of that piece. Thanks for your time.
Good to be with you, Pedro.
We will talk about issues of debt and the deficit with the Bipartisan Policy Center's Bill Hoagland. He'll discuss the potential of the national debt tripling within 30 years. And then later on in the program, Reveal reporter Will Carless on his recent piece about the hundreds of active duty and retired law enforcement officers being members of online hate groups. Those conversations coming up on Washington Journal.